Thank you very much for joining. I'm Brendon Lesar from the firm Harrington Carmichael, and I work in the commercial department, and we'll be doing the presentation today on tips and tricks for contracts, which will hopefully give you a general oversight of some things to watch out for, and hopefully assist you in improving your business and avoiding some of the pitfalls when dealing with contracts. All right, Harrington Carmichael, we're a full-service law firm. We give advice to UK businesses as well as international businesses, and we work with entities of all sizes, PLCs and through to startup businesses. And this presentation is mainly geared for the small business, the startup business, to assist you with some legal knowledge, some background to help you with navigating the complex legal world. We are rated as a leading law firm, and quite proud of our achievements that we've achieved recently. The WISE setup that we have, which is the Insights for Startups and Entrepreneurs, they're aimed at individuals, small businesses, so we can share knowledge with you and information and hopefully assist you in kickstarting your business. We do offer a free office space at our Farnborough office where entrepreneurs and startups can meet. And you've got access to our expertise here and, of course, a full-scale law firm to assist you with all of your needs. If you need any information or would like more information, you can email us at hub@hc.law for further information on what we offer with WISE. All right, today we're going to cover a brief introduction to contract law, go through some legal jargon, and hopefully give you some explanation what those words mean, look at some contract terms, and give you some pointers on the risk of failing to comply with the contract and what actually can happen if you're in breach of a contract. There we go. All right, formation of a contract. When does a contract start? How do you enter into a contract? What are some of the points to consider? The main thing is you've got to start with an offer. If you make an offer, it's got to be specific and it must be complete. When I say complete, if you make an offer to a person, it should contain your terms and conditions in that offer. Otherwise, it's not complete. The offer must be made in such a way that it's capable of being accepted. And when you make the offer, you must be intended to be bound if the other party accepts it. So if you're asking the other party to simply negotiate with you and to send their offers and you would consider accepting it, then you haven't made an offer. So consider that carefully with what is your intention, because if you make an offer and the other party accepts it, you're bound by those terms. So you've got to be clear when making an offer, make sure it's specific, refer to your T's and C's in that offer so that your T's and C's are incorporated into that offer. When accepting the offer, your offer should specify for them to accept it. It should be in writing, if that's one of your terms that you want in there. They've only got a limited time to accept your offer. So specify that this offer is valid for 7 days, and if they don't accept it within those 7 days, then the offer will fall away. And if your offer does not refer to your terms and conditions, then you may be faced with a situation where your terms and conditions are not included in the offer, and that could be a problem for you when you do want your terms and conditions to apply. If the other party varies the offer, then they haven't accepted your offer, but they've actually come back with a counter offer. And then you've got to look at that carefully, because if you accept their counter offer, it could be on their terms. So always make sure that your offer is specific, gives instructions on how they should accept it, whether in writing or whether they can communicate to you verbally, whether the offer is open for a certain time period only, and whether the person accepting the offer, when they send through that acceptance, whether they've complied with all of those things to ensure that a valid contract comes into force. Contracts can also be written or oral. However, in some circumstances, contracts have to be in writing. For example, if you're selling property, you can't have an oral agreement. The law states it has to be in writing. If you want to assign certain IP, in certain circumstances, it can't be done in any other form except in writing. So don't always think that an oral agreement can be enforceable. In certain times, it should be in writing. And as lawyers, we'd always recommend it being in writing because it comes down to issues of evidence, proving what he said, she said. If there's a dispute on what the terms were on the oral agreement, it's much easier if it is in writing. And if the parties agree to anything else afterwards orally, one of the parties should record it in writing to the other to say, just confirming how we're changing the contract. Here's my email to say we will now do it this way, so that you have the evidence in case there's a situation that goes wrong. Another form of the vital ingredient of contract law is there must be consideration. What that means is you require the other party to do something, such as pay for the service. If the agreement is just provide a gift to a person, then that is not a contract that is enforceable because it doesn't have a consideration. So sometimes in a contract, you would see a clause there that states, in consideration of the services, I hereby agree to pay £1, which is duly accepted by the other party, and therefore consideration is given in that contract to make that contract legally binding. There are certain types of contracts that require consideration, and there should always be that aspect. For example, if you're assigning a right where someone's just getting something from you, you would put that consideration clause in there. If, of course, you are selling a service and they're paying you for it, then the consideration would be that person paying you for that. Also, when there is termination of a contract, you should also consider whether there are any fees payable, any cancellation costs, and what clauses should survive the termination, because afterwards you may need to rely on any indemnities that you have in that contract, so they need to survive the contract. If there's limitation of liability clauses where your liability is limited, that should survive a contract that is terminated, because if something arises 6 months after the contract ends for something that happened during the contract, you would need to rely on your limitation of liability clause to have the benefit of that. Confidentiality clauses, whether that is applicable to survive after the contract, especially if you agree for the parties to keep information confidential 5 years after the agreement terminates. But if your confidentiality clause is not stated to survive after the termination, then you won't be able to rely on that. Normally, these type of clauses is what we would put in a contract to survive after the contract. Next, we look at the structure of a contract, standard terms and conditions. How do you incorporate them into your contract? As I stated, in your offer, you could refer to your terms and conditions, but reference to terms and conditions only is not enough to incorporate it into a contract. The other side, remember we said an offer needs to be specific and complete. So the other side must be given an opportunity to read them. What we suggest in practice is that don't just say our terms and conditions will apply, but actually put a link to your terms and conditions or attach your terms and conditions. Then your offer is complete in that the other party has a reasonable opportunity to read them, either by going to your website where you've given them the actual documents or the link to your documents, or you've attached your T's and C's to the offer so that they can accept it. Purchase orders. If there's a purchase order, once again, refer to your T's and C's, but put a link to them. Don't just simply say our terms and conditions will apply at the bottom of it. Similarly, acceptance of orders that we discussed, the other party must accept it by either communicating it to you in the form that's accepted, or they could accept it by their conduct, that they actually just start paying you in terms of that, and then you can assume that it's been accepted. But for you to accept it and make sure that you are not willing to reject it, you can go back to the party saying, no, we wanted your acceptance to be in writing. We wanted it to be within 7 days. So we therefore can reject this order of yours. Putting your terms and conditions in your invoices, it could be considered too late sometimes, because the whole process, offering, accepting it, may be too late if you only invoice them afterwards. And only referring to your terms and conditions in your invoice could be considered too late, because their terms could apply when they accept it, and their email footer says our terms and conditions apply when accepting orders. So always look out for that. Try and put your terms and conditions in the first communications to the other party, in making sure that they apply. If any of their acceptance letters or forms that they send to you refer to their terms and conditions, a party may then be faced with the battle of the forms. I know we've previously done a presentation on the battle of the forms and how to make it apply, but just to point out there that normally the last shot wins. So whoever fires off their or refers to their terms and conditions last, those terms and conditions apply. So it's prudent for a business to refer to it on your offers. If there's purchase orders, refer to your T's and C's there. Refer to it in your email footers if you communicate via email and accept orders that way. Just make sure that your T's and C's are referred to in as many places. And if the other party's documentation they sent you refers to theirs, pick up the phone and say, actually, we do not accept your T's and C's. We want ours to apply, and we're making this, we're highlighting this point, and please can the parties agree separately, and the other party can then email you saying, yes, we confirm yours will apply, and then that's a way to avoid theirs applying. Onerous terms in contracts. Between business to businesses and business to consumers, different things apply. If a term is deemed too onerous, the court could look at it and say it's unenforceable. And if that term's unenforceable, it could be cut out of the agreement, or the whole contract could be unenforceable. So if you're going to put onerous terms into your contract, draw it to the attention of the other party. In your T's and C's at the top, say, for example, please look out for clauses 6, 7, and 8. These are important, and we want to draw your attention to it, that they cannot come and say they were not aware of it. If you're dealing with consumers, there's certain different rules regarding what obligations you can put on them. And if your terms are too onerous on consumers, there again, they could be unenforceable. And especially dealing with consumers, we would recommend obtaining legal advice on that. Previous course of dealings. If the two parties are doing business regularly and they're not really sticking to the T's and C's and the ways of ordering and accepting, and when payments are made, you say payment within 7 days, they normally pay within 10. It's carried on that way for a period of time. Your course of dealings between the parties could be implied as to how the contract is now working between the parties. And if there's been a course of dealings, you can't, after a length of time, say to the other party, oh, you're actually in breach. If it's become the course of dealings, these could be implied as being in use, and you won't be able to rectify that. So if there are deviations from the contract, always highlight it to the other party, tell them that is in breach of the terms and that they should rectify it. That's why in full form contracts, if, however, a contract is negotiated, it's not just accepted on your standard terms and conditions, then, and the parties have looked at different terms and changed payment dates and limits of liability, and they've actually negotiated the contract, then the more onerous terms are likely to apply, and the court won't throw them out because of them being too onerous. Sometimes you're faced with a situation that neither party's standard terms apply because of the backwards and forwards with both parties saying their terms apply. The court could find out that neither party's terms apply. When this happens, you're not left without anything. You actually have some rights. If you're a supplier, you can claim restitution for what you've sold. However, you're only entitled to reasonable payments, not exactly the amount you wanted in the contract. For the buyer, though, they would be in a situation that if neither party's terms apply, they wouldn't have the normal remedies of breach of contract that they could rely on. Legal jargon and terminology will be the next point I'll discuss. Material breach. A lot of people refer to material breach. What is it? When does it apply? It's defined as a significant failure by one party to fulfill terms. So it's got to be significant. For example, failure to pay would be considered a significant failure to fulfill one of the terms. And if there's a material breach, then you will have certain remedies. If the person has breached it, you can either cancel the contract, or if you have other terms in the contract, you could claim damages from them, either liquidated damages, depending on what circumstances apply. Good faith, what does that mean? In UK law, there is no general duty of good faith, and it's not implied into a contract that the parties should always act in good faith with each other. So if you want the parties to act in good faith, put that in your contract, and that will require the other party or both parties to always act honestly and fairly with each other and to not act outside the contract. But if there is no duties of good faith, it won't be implied into the contract. It's not part of UK law, and you will not be able to rely on it if that other person is not sticking to everything 100%, is not always dealing fairly and honestly. One of my favorite ones, reasonable endeavors, all reasonable endeavors, best endeavors. What do these mean? What is expected of you? Reasonable endeavors means you need to take one reasonable path in your own commercial interest. And you will always find reasonable endeavors or best endeavors, all reasonable endeavors. Look very carefully if you've got wording in your contract from the other party that says all reasonable endeavors or best endeavors, because those mean you need to take all reasonable steps, not just one reasonable step. You need to take all reasonable steps to comply with that term. And it also means you need to sacrifice your own commercial interest. You're required to actually incur significant expenditure, but not to the point of being ruined, but you do have to sacrifice your commercial interests. Therefore, please do not look at reasonable endeavors and best endeavors as a similar obligation on you. Taking one reasonable path in your own commercial interest, which means you don't have to spend exorbitant sums of money to comply with that. You only need to take one reasonable path. But to take all reasonable steps requires you to try 10 or 15 different things and sacrifice your commercial interests. So always watch out for those terms. And if there is best endeavors in a contract on you, ask them to bring it down to reasonable endeavors. Assignment and novation, what do these mean? It's a way to transfer rights to another party. Assignment, however, only transfers the rights and benefits. Novations, on the other hand, transfers the burdens of a contract. That means the obligations to pay money or deliver the service. Assignment is only the benefits of a contract that is transferred to someone. In your contracts, normally you'd keep assignment and novation rights that only you can do it and not the other party. But if the other party is allowed to do it, that means they can novate the contract to someone else, and all of a sudden you're in bed and doing business with a party that you didn't intend contracting with. So look out for those clauses and see what is beneficial to you and whether it is required for the other party to also have those rights. Force majeure, that was a hot topic during COVID. Everyone was looking at those clauses to see if they can rely on it, because due to COVID, people couldn't perform their contracts, and they were looking at whether they could rely on their force majeure clauses. In UK law, there's no definition of it. So the definition would be what is in your contract. A lot of contracts say force majeure would be act of war, terrorism, fire, flood, and none of them refer to pandemic. Therefore, you couldn't rely on the epidemic to prevent yourself from performing the contract, where in reality, you couldn't perform the contract. So make sure that clause is worded wide enough to cover you. It's generally defined as events beyond your reasonable control. You can list out examples of what would be considered force majeure events to make that are specific to your business, such as truck services on strike and you rely on the trucking companies. You need to make sure that that's covered in there as what's considered an event that you can rely on if you won't be able to perform the contract if these sort of things happen regularly. Warranty, what does that mean? It's a contractual assurance given from one party to another, and a warranty lasts for the duration of the contract. Whereas the one below it, representation, it's where one party asserts a fact as true to enable the other to induce them to contract. However, a representation is only valid at that date, where a warranty is for the duration. So if someone makes a representation to you in the contract saying, I make these representations, those are only valid at that date of the contract. So 2 weeks later, those representations are not valid anymore. Therefore, it's always better to have warranties from the other side that their product will meet these standards, that it will conform to these specifications, etc., instead of having representations from the other party. So look out for those wordings, and especially in your T's and C's, it'll always be better for you to give representations and warranties, because you're asserting your facts as true as of today. But in 3 months' time, if those things aren't true, they can't come back to you on that. Indemnity, those are clauses in a contract where there's an agreement from one party to compensate another, and indemnities can either be one way, where one party agrees to indemnify the other, or they can be mutual, that both parties agree to indemnify each other. For example, any breach of data laws, the other party would compensate you for any losses you suffer, or both of us will indemnify the other if one breaches any data protection laws. So make sure there are indemnities for certain things, because there could be big fines for breaching certain things. And if you require an indemnity, ask for it. And if you are entering into a contract with another party on your terms, make sure that the other party will indemnify you for certain things that you consider risky. If they breach your confidentiality because you've given them extremely important intellectual property to use and they misuse it, you want them to indemnify you for those sort of things. Clauses to look out for when you get a contract from the other party, or even in your own contract. Look at the limitations of liability. It'll set out the limits, what types of liability are covered, what types of losses can be included in the overall cap on liability, what losses are excluded, example, loss of profits. The limitation of liability could be a set amount, £10,000. It could be the value of the contract. The contract may have a very small value and therefore may only be limited to £100. So always look at, if the other party has a limitation of liability clause, whether if they breach it, whether that limit is sufficient for you to recoup your losses, and if not, try and negotiate that clause or get them to have a minimum amount of at least £5,000, for example. Indemnities, we touched on it. As we said, the other party must pay you an amount of specified money if a specified event occurs. So in your indemnity, in general, you can't recover unforeseeable losses. So you should specify in the indemnity what sort of losses they should indemnify you for. If it's indirect losses that you want them to indemnify you, include that in the indemnity. If it's penalties or tax obligations, those should be included in the indemnity. You should also decide, when are they payable? Is it payable immediately on demand? Is it payable when a certain event occurs? And as we said previously, is it a one-way indemnity? Who is it applicable to? Or is it a mutual indemnity that applies to both? Or it could apply to that person as well as his group companies. So quite a few ways to structure indemnities. Confidentiality, as touched on, it's important, if you've got confidential information, to define what is confidential and what will fall within confidential information, who it must apply to. Do the confidentiality provisions apply to both of you, or is it only to the one party? Time periods, is it only during the contract that the parties are obligated to keep information confidential that they've shared with each other? Or is it important that they keep certain information about your business confidential for 6 months after the contract ends, or a year? The parties, if they negotiate these time periods, it can apply, but you don't want to go and put time periods on that could be considered too onerous, and then that is struck down. Same with intellectual property. If you've got highly sensitive intellectual property and you're sharing it with the other side, then you must clearly define what constitutes it, who has the right to use it, whether it's only that person, is it his group companies as well, what is the length of term they can use it for, will they be able to use it after the contract ends or only during the contract? So if you have highly sensitive intellectual property to be shared with the other party, then this is a point you should consider carefully and obtain legal advice on. Similarly, if you're using someone else's intellectual property, think about how long you need to use it for. Do you need to use it after the contract? If the contract terminates, can you carry on your business without that person's intellectual property? Are you prevented? Look at those different terms, because it could hamper you in your business if the contract ends. Breach of contract will be the next topic we discuss. One should always look at, has there actually been a breach? And the easiest ways to look at this is, are there express terms that have been breached? Now, an express term means that is expressly stated in the contract, where an implied term that's not stated in the contract. If there's an express term that has been breached, then in general will be considered material. And if a party has breached an express term, it could lead to liability for damages. If it's an implied term that's not agreed or written in the contract, then one would have to see if the implied term has been breached. But implied terms could be put into the contract by a court. It could be implied by legislation. For example, the Sale of Goods Act. The Sale of Goods Act, if you're selling certain products, implies certain terms into a contract that you have to abide, that it'll be of satisfactory quality, for example. And if you're not aware of those, and the other party sues you for not providing a product of satisfactory quality based on an implied term, do not think you're scot-free because it's not in your contract. It could be contained in legislation or common law, or even how you've been dealing with the other party. As we said previously, course of dealing could result in the term being implied into a contract. When looking at a breach, can you look if you can claim under indemnity, a warranty, or a presentation? Is the first places you'll look at in the contract. Secondly, you'll look at what type of damages you can claim. Are they liquidated damages, which means it's a specified amount? If a person delivers late and they said they will deliver your order within 7 days. Every day that they're late is costing you money. In your term, in your contract, you could say they have to pay you £100 for each day that they're late. If that is specified, then you don't need to prove your loss. It's an easy calculation. You wouldn't have to be in the position that the court would need to prove your loss for each day that they're late, which would happen on a breach of contract claim. So if it is important, put it in there and have a specified amount for each day late that there'll be liquidated damages. But there again, if the liquidated damages are too high, it could be considered a penalty, and penalties are unenforceable, and that whole clause could fall away if, of course, those liquidated damages are too high. If you're faced with a situation that the breach that they've done gives you the option to either rescind the contract or claim damages, it's an important decision to make, deciding what to do. Rescinding the contract means undoing it as if it never took place and putting the parties back into the same position before the contract started. That might be a better position for you. Alternatively, a better route to follow would be to sue them and claim damages. These decisions could have huge financial consequences depending on which way you go. And that's why when there's a breach, if you're unsure, speak to the lawyers at the outset, look at your terms, and immediately look at what their contract says about putting them on notice of the breach. Because some clauses and contracts have references that if there's a breach, you have 14 days to cure it, and the other party will first notify you in writing. If you don't receive that notification in writing, then you're not under a duty to cure it. So if your contract states the other party must do those things, give them notice as soon as possible. Do it in the right terms. Don't just pick up the phone if your contract says it must be in writing to give them notice of the breach. And similarly, if you've received that notice of the breach, look at the time periods, because you only have 7 days to cure the breach, or 14 days. Comply with the time period. Comply with the format that it must be in writing. Look at your notices clauses, because the notices clauses could say all notices must only be served on certain addresses. So you can't email it to them if that is not in the notice clause as a way to serve a notice. So when dealing with giving a notice, check all these things off. Keep it in the back of your mind that it has to be complied with to the letter of the law, with when notice must be given, in what format it must be given, and to where, their registered office or by email, etc. So reducing your legal risk, please always look at, before you sign a contract, make sure you understand your position. How the clauses affect your level of exposure? Look at it, think of situations and circumstances. Look at the obligations your business may be held to. Look what indemnities and warranties you may have to give and whether they are reasonable or not. Look at the amounts and what type of things you are required to indemnify them for. Look at the warranties they expect you to give, or the warranties they are giving. If they're not giving enough warranties, ask them to say, you must at least warrant that your intellectual property won't breach third-party rights, because you don't want to use their IP and it breaches the third-party rights. So always seek legal advice in these sticky situations. If the contract's been breached, either by yourself or the other party, speak to solicitors. Make sure you can reduce the impact and your risk, because you don't want to be faced with a claim for damages or a situation that could lead to unnecessary financial detriment to yourself. If you're in a large organization, keep up the lines of communication with your management, seek assistance, and don't just bury the mistake. Rather deal with it there and then and say, oh, we've breached this contract. Let's try and rectify it. So if you need advice on any of your contracts, I'm Brendon. My senior partner is Mark Chapman. You can contact us on my email or Mark's email addresses or our telephone numbers. So that is the end of the presentation, and I really appreciate your time.